I'm going to be doing an overview of the adult guardianship process in New Mexico today, as well as spotlighting the alternatives to guardianship that everyone should be considering before pursuing a guardianship action in New Mexico. My name is Ashley Hogan. I'm the Medical Legal Partnership Attorney at New Mexico Legal Aid. And I'll first start with just describing what a medical legal partnership actually is. So what a medical legal partnership is a collaboration between a civil legal aid organization, so in this case, New Mexico Legal Aid, and a healthcare facility. Currently, the partnership I'm working with is located at Christus St. Vincent Hospital in Santa Fe. The legal aid attorney is available to represent and advise patients of the partner healthcare facility who have health-harming legal issues to help address those issues so the patient can concentrate on improving their health. In addition to providing those direct legal services to the patients, because I'm actually embedded in the healthcare facility, I can also train and speak to the healthcare providers on how to screen for patients in need of legal services and provide training on the basics of some of the common legal issues that are affecting the patients in that healthcare facility. So to put the partnership and the medical legal partnership model into context, I just have a few slides here to demonstrate the purpose behind all of this. So let's say we have this person with an underlying health problem. And then, imagine that he or she is having trouble paying their bills, maybe due to a situation of unemployment. Then on top of all of that, maybe there's family violence in the home, domestic violence that they are suffering from. And then finally, maybe due to being not able to pay their bills because of the unemployment or due to, lease violation notices because of the violence, they're now facing a housing eviction. So I think it's very clear from this image that with all of these problems piled on top of each other and getting worse and worse, it's going to be very hard for this person to focus on their underlying health problem. So the purpose of the medical legal partnership specifically is to address as many of these problems on top of their health problem as possible to allow them to focus on their health. So some common legal issues that we will see as a medical legal partnership include the economic security issues, so Medicaid and Medicare insurance denials, issues with Social Security benefits, SNAP, TANF, unemployment appeals, and disputing unfair debt collection practices. We also deal in the housing issues, so eviction or foreclosure prevention, as well as disputing housing voucher terminations and trying to remedy unhealthy or unsafe living conditions. We also address personal safety issues, so we can petition for orders of protection from domestic violence, stalking, and report elder abuse and elder exploitation. And then also we work in decision-making issues. So we do execute and explain advanced healthcare directives, financial powers of attorney, as well as if the person lacks capacity, speaking to a family member of the patient about guardianship. And I think one person's unmuted. Everyone could see if they're muted.
When I had a chance.
So then today I'm going to be focusing on this last area, the decision-making area, and address alternatives as well as the actual guardianship process. So I wanted to start with just some guiding principles. If after this talk, these are the key takeaways that you have from this presentation, that would be great. So the first guiding principle is that before you think about guardianship, you should consider and exhaust all alternatives to guardianship prior to actually starting a guardianship case. Guardianship is always going to be an option of last resort. This is because it is a very drastic measure. It takes away a person's right to make their own decisions and gives it to someone else. So the way I think about when guardianship is appropriate is a two-pronged decision. So the first is that the person you're considering guardianship for is unable to participate in the decision-making process in a meaningful way. And then two, that there is an imminent need for decisions to be made to protect the person or the person's property from harm. So if you have both of those things, then you can start thinking about whether guardianship is appropriate or if there is another option on the table. So guardianship is only appropriate when there is no other legal authority to make the necessary decisions to protect the person or their property, or when it is the only way to address abuse, neglect, or exploitation. So this means that if there is a power of attorney for healthcare decisions in place, you likely can rely on that and you don't need a guardianship to make healthcare decisions. Similarly, if there's a financial power of attorney in place, you're going to rely on that over seeking financial authority to make decisions through guardianship. And then the final guiding principle is that when you do seek guardianship, and if you are granted guardianship over someone else, you should always think about limiting it in both time and or scope. So either the duration of the guardianship, maybe you only need it for a year and then you can reassess, or the scope, maybe you only need it for finances, or maybe you only need it for health decisions. So whenever possible, try to be as the least restrictive option on the person's protected civil rights and liberties. So those are the guiding principles that I have today. And I wanted to also just highlight specifically why I want to speak about alternatives. So this is from the New Mexico statutes, and it specifically addresses when guardianship should be used. So guardianship for an incapacitated person shall be used only as is necessary to promote and to protect the well-being of the person. It shall be designed to encourage the development of maximum self-reliance and independence of the person, and shall be ordered only to the extent necessitated by the person's actual functional, mental, and physical limitations. An incapacitated person for whom a guardian has been appointed retains all legal and civil rights except those which have been expressly limited by the court order or have been specifically granted to the guardian by the court. So this specifically is saying that it really is only designed to be for necessary decisions and should be as limited as possible. So just keep that in mind if you are considering guardianship, and think about ways to limit it if possible. So now, since this is such an important area, I do want to spend some time on alternatives to consider. And all of these are going to depend on the capacity of the person that you are seeking to protect or to help. So the three areas I'm going to talk about are a supported decision-making model. So this is a non-legal remedy. And then financial decision-making tools. So this will involve some actual legal documents in some cases, or authorizations, and then the healthcare decision-making tools as well. So if you have both the financial and the healthcare decision-making tools in place, you will hopefully be in a place where you won't need to pursue guardianship in the future, because guardianship is meant to address these two areas, finances and health. So let's first talk about the supported decision-making. This is for someone who has diminished capacity but can participate in a meaningful way in discussions and decision-making. It's a person-centered, person-driven decision-making model. It really leverages the person's ability to make decisions for themselves, so it promotes their independence, even when they have diminished capacity. So to describe the model, you have a person in need of assistance when making decisions. They consult with a person they trust to help them understand their options, and they listen to that guidance. The person providing support asks the person in need of support what they want to accomplish, what decision they want to make. They walk them through the factors to consider to achieve what they want, what that means. For example, if they're Considering new housing, they can walk them through what their income is, what the cost of that housing is, how much would be left over for food, are they considering a safe neighborhood, some things that maybe a person with diminished capacity wouldn't think of on their own, but that they may have the ability to understand if someone walks them through it. And then the person in need of support makes their own decision after listening to and understanding the guidance. This level of support and the level of support that person may need depends on the level of capacity. I think this is a great model to consider for minors with disabilities who are reaching the age of majority. It might seem logical to go to guardianship if you have a disabled child. Maybe you think you need guardianship right away when they turn 18. But if they are able to participate in decisions and you want to promote their independence and ability to make decisions for themselves, this could be a good place to start and explore and see if this could work. And the process can be informal, so it can just be, as you go along, or it can be a formal written agreement where you actually write down a plan and follow that every single time a decision needs to be made. All right, so the next area I'm going to talk about are financial tools. So the first is a financial power of attorney. This has to be executed while the person has capacity to understand what the power of attorney means. It's a legal document that permits a person to designate another to make financial decisions on their behalf. There is an optional form available provided by the New Mexico legislator, and I provided the statute number there. The authority granted under a financial power of attorney can cover just certain financial transactions to put in some safeguards, or it can give just a general authority to handle all financial matters. The document must be filled out, signed, and notarized when the person has the ability to understand the power they are designating. The person executing the document is called the principal, and the person designated as power of attorney is going to be called the agent or the attorney in fact. The agent owes a fiduciary obligation to the principal, which means in general, they just must act in the principal's best interest. And these financial powers of attorney can be drafted to either be immediately effective, so the person can start making financial decisions, access their bank accounts, things like that as soon as it's signed, or it can be a springing power of attorney, which means that the power of attorney will spring into effect only after medical professionals have deemed the principal to lack capacity. And I also just wanted to note as well, with financial powers of attorney, they can be revoked just verbally or in writing by the principal anytime they have capacity, but they do survive the person losing capacity as long as they have not been revoked. All right, so other financial decision-making tools to think about and consider if the main problem that the person you're seeking to protect, if their main problem is finance management, you can, if they have Social Security benefits, you can request to be made the representative payee. This person is appointed by the Social Security Administration to manage the Social Security benefits for someone when it's shown that they are unable to manage their own finances. I did want to note as well that if the person has Social Security benefits, the Social Security Administration will not acknowledge a state financial power of attorney. So you will likely need to seek to be representative payee even if you are the financial power of attorney. You can also consider helping them set up an auto bill pay process. So if you know, for instance, that auto bill pay is set up for their utility bills, rent, mortgage payments, the big items that will really create instability, it can help a person with diminished capacity or temporary periods of incapacitation maintain stability through that period. And, potentially you won't need to seek guardianship to protect their home or to keep them from going into debt collections statuses because that auto bill is set up. And then finally, this should really only be considered for, probably a spouse or an extremely trusted person, but you can open up a joint bank account or authorize someone to access your bank account. But this one I just give with extreme caution because there is such a big opportunity for exploitation because they will just be an authorized person on that account to use all of the money in that account. So now I'm going to switch over to the healthcare side of things. So healthcare decision-making tools. I'm going to just give a brief overview of these four. These are the four most often used. So the optional statutory advanced healthcare directive form, again, this is a form provided by the New Mexico legislator, an optional form you can use. It's similar to a financial power of attorney, but it designates a person to make healthcare decisions for you. And it is easier to execute because it does not require notarization. It suggests 2 witnesses, but it's not required to even have witnesses. But I do recommend that someone be there and witness the execution of these advanced healthcare directives. There's also a MOST form. This is a form similar to an advanced healthcare directive, but it's also signed by a healthcare provider. These are a good idea for people with diminished capacity or people coming in and out of periods of capacity because you have the healthcare provider's signature on there, which suggests that this person did have capacity when they filled out the form, and the doctor was there and able to explain the healthcare decisions that are included in this form. So that's a good idea to have in those situations. Surrogate decision maker. This is typically used in hospital settings. So the New Mexico statute permits a person to make physical healthcare decisions for an incapacitated person if 2 healthcare professionals assess a patient to be incapacitated. The statute provides a list of persons who can serve as surrogate decision maker by order of priority. The priority is mostly based on family relations. So you're going to have a spouse, a child, a parent, in descending order of priority, all the way down to a friend or even an adult who takes a special interest in the patient. Hospitals sometimes provide an affidavit for the loved one to sign if they identify a loved one that can serve as a decision maker. And the patient is found to be incapacitated. So that's just an affidavit saying you are who you say you are, spouse, daughter, cousin, and the person and you'll act in their interest. And then you just sign that so that you can be their surrogate decision maker. This surrogate decision maker, the decisions that they can make typically are going to be only physical health decisions. So surgeries, discharge, placement, they're going to be able to make just the health decisions at that time. And then advanced healthcare directive for mental health treatment. I don't see this used very often, but I do want to recommend it, especially for people with struggling with mental illness. It's a form that is very detailed as far as the choices you want to make for the future of your mental health treatment. It allows you to designate, again, a person to make mental health treatment decisions for you. And it also allows you to direct your mental health care treatment if you experience a decompensation event that renders you incapable of making informed decisions. So this means that this one cannot be immediately effective. This one is only effective when you lack capacity. And it allows you to say things like, certain treatments work better for you, certain drugs work better for you, the doctor that you would like to see if you have the chance, or a doctor that you did not get along with. So I think this is a great one for anyone who has struggles with mental illness. All right, so those were the alternatives, and I'm going to keep an eye on time here. Okay, so I do want to get through the types of guardianship in New Mexico, and then also just some legislative changes. So I might go through this a little bit more quickly. So the types of adult guardianship in New Mexico to know about: there are treatment guardianships, where a court appoints a person to consent to the mental health care treatment for a person that is incapable of giving informed consent for such treatment. And then the more typical, maybe the one that you think of when you think of guardianship, is the adult guardianship statute, where a court appoints a person to make a wide range of decisions, including medical, residential placement, and financial decisions to provide for someone else's well-being. This can be limited, so it can be limited in the scope of the guardian's authority, so it can only cover specific decisions or a category of decisions. And then within the adult guardianship statute, there's also the option to have a temporary guardian appointed for, currently it's usually 60 days, although there are legislative changes coming up that will limit that. And this will limit the scope of the guardian's authority to a specific amount of time in an emergency situation, but it does allow them to be appointed before the actual full hearing on the adult guardianship. And then finally, there is conservatorship, which is appropriate if the person in need of protection has significant assets. So just to quickly do an overview of the treatment guardianship process, this is typically going to be initiated by the actual behavioral health treating physician. So a treating healthcare professional or an interested party, it doesn't have to be a treating professional, they will file a petition in district court asking for a treatment guardianship to be appointed, only if there is clear and convincing evidence that a person is not capable of giving informed consent to mental health care treatment. The specific information that must be included in the petition is outlined in the New Mexico rules at 1-130C. The petition must be personally served on the respondent, and the respondent is the person for whom the treatment guardian is sought, as well as the respondent's attorney. The respondent must be represented by an attorney in a treatment guardianship action, and the court is able to appoint an attorney if necessary. These treatment guardianship processes are very quick. The hearing on the matter should be set within 3 days of filing of the petition. And at the hearing, the treating healthcare professional will testify about the respondent's inability to make an informed decision about mental health care treatment and testify about the proposed course of treatment. The respondent or his attorney may contest the proceeding and may call witnesses at the hearing to argue for why a treatment guardianship should not be granted. The treatment guardianship, if it is granted, cannot exceed 1 year. And then a court order appointing a treatment guardian can be appealed or terminated voluntarily, as well as individual decisions of the treatment guardian can be contested through court action also. So just quickly to go over some definitions that are in the statute to have everyone understand what I actually mean when I'm saying capacity to make healthcare treatment decisions. So it's going to be when a person has capacity to make healthcare treatment decisions when the person has the ability to understand and appreciate the nature and consequences of proposed mental health treatment, including significant benefits and risks and alternatives to the proposed mental health treatment, and to make and communicate an informed mental health treatment decision. And then this is also just the definition of mental health treatment. So it includes, but it's not limited to, the administration of psychotropic medication, psychosurgery, convulsive therapy, experimental treatment, or behavior modification program involving aversive stimuli or substantial deprivations. So anytime a health provider is recommending one of these treatments, it's going to fall under this statute, and it will require a mental health decision as opposed to a physical health decision. All right, so then the plenary guardianship process, or the adult guardianship process, this is when a family member or the state is going to intervene on someone's behalf and say that they need a guardian to protect them. So any person who has an interest in the welfare of the person to be protected will file the petition again with the district court. And this time they're asking the court to perform an extensive investigation into the person's ability to care for themselves and make financial decisions. Again, I provided the statute where all of the information that must be in the petition is outlined. The notice, so notice must be provided to parties that would have an interest in the proceeding. So there's a case information sheet that you have to fill out listing other family members, potentially other close friends if you know they would have an interest in the proceeding. And many people are entitled to notice in this type of action because the court wants to give the opportunity for as many points of views and the opportunity to dispute the guardianship as possible to protect the alleged incapacitated person. The petition must be personally served on the alleged incapacitated person. So this means it must be hand delivered to the person and otherwise served on all of the interested parties. So that can be through mail or email. A qualified healthcare professional report is also filled out by the healthcare provider, and that is also filed at the same time as the petition. That healthcare professional is then appointed by the court as the qualified healthcare professional for the case. The court appoints then a guardian ad litem as well as a court visitor after the petition is filed. And then not less than 60 days after the petition is filed, the court will hold a hearing on the matter before a plenary guardianship can be granted. The only type of guardianship that can be granted before the hearing is that emergency temporary guardian, which in the future should only last 30 days with the chance for an extension, but currently can last 60 days. So with all of that information, I just wanted to give a brief list of the documents that are included in this type of action. So the petition with the qualified healthcare professional report is what's going to start the case. You're going to then do the request for hearing as well as a very specific notice of hearing that gets delivered to the respondent, the alleged incapacitated person, which outlines their rights in the action. Once the court appoints the guardian ad litem and court visitor, you will then have the guardian ad litem report as well as the court visitor report filed to the judge. The judge will then review them, have the hearing. At the hearing, there will be the chance for disputing the action. The court, if they agree a guardian should be appointed, will issue an order appointing guardian. The guardian will file an acceptance of guardianship form. The court will then issue letters of guardianship. So the order appointing guardian and the letters of guardianship are what the guardian will use to show they have the authority to make decisions for this person. And then finally, the guardianship report is going to be due after the guardianship. The interim report is due, and then there are annual reports due to the court that must be filed. So just to give a brief, again, summary of the people who are involved, since there are actually a lot of different players and different people who have to be involved in this process. The actual parties are going to be the alleged incapacitated person or the protected person or the respondent. So all of those people are going to be the same person, just called something different. And then the petitioner, the person saying this person needs a guardian. And then the other players are going to be the petitioner's attorney, the qualified healthcare professional, the guardian ad litem, and the guardian ad litem is usually an attorney who serves as the representative of the respondent, so the person in need of protection. They do a lot of the investigation, so they conduct interviews with relevant parties. They're going to review medical records for the protected person, and they are going to issue that report to the court with the recommendations for whether the person needs a guardian and who the guardian should be. The court visitor has a similar role, but they are unbiased, so they don't represent either the petitioner or the respondent. They make their own recommendations. They are always going to be a social worker, and they additionally investigate the matter and present the court with a report outlining the alleged incapacitated person's ability to care for themselves and the appropriateness of a guardian. The final decision maker is going to be the district court judge, and then there may be additional witnesses called by the respondent. If they do not feel that they need a guardian, they can call their own doctors. They can testify on their own behalf. So again, just some quick definitions. Incapacitated person is going to be any person who demonstrates over time either partial or complete functional impairment by reason of mental illness, mental deficiency, physical illness or disability, chronic use of drugs, chronic intoxication, or other cause except minority, to the extent that the person is unable to manage the person's personal affairs, or the person is unable to manage the person's estate or financial affairs, or both. And then they do define inability to manage the person's personal care. So that is going to be the inability as evidenced by recent behavior to meet one's needs for medical care, nutrition, clothing, shelter, hygiene, or safety, so that physical injury, illness, or disease has occurred or is likely to occur in the near future. And then inability to manage the person's estate or financial affairs, or both, means the gross mismanagement as evidenced by recent behavior of one's income and resources, or medical inability to manage one's income and resources that has led or is likely in the near future to lead to financial vulnerability. So it is more than just a few, bad decisions or use of drugs on an occasional basis. It really means that there's evidence that the person is unable to care for themselves or unable to manage their finances in a way that is going to or has caused them harm. All right, so I did want to present the legislative updates because there was a Senate Bill 35 passed that will go into effect on July 1st, 2022. It makes changes to the temporary guardianship process in New Mexico. So again, that's the one that you seek in emergency situations in order to act as guardian for a temporary amount of time to protect that person's either physical or financial well-being. So the Senate bill that passed is going to provide additional protections for alleged incapacitated persons, so the respondent in the case. It will prohibit a temporary guardian or conservator from selling or disposing of property or changing the placement, so the housing of the alleged incapacitated person, without express court authorization. There will also be a 10-day deadline to have a hearing on the appointment of a temporary guardian or conservator. Let's see here. They are going to be requiring appointment of a guardian ad litem and a guardian ad litem report prior to the hearing 10 days after the request for temporary guardian is made. And like I mentioned previously, now the temporary guardian is not to exceed 30 days in length. However, it can be extended for an additional 60 days only upon a showing of good cause that it needs to be extended. And then the temporary guardian report is going to be due 15 days after the appointment of a temporary guardian. So the person appointed will have to issue a report 15 days in saying what decisions they've made for the person. Additionally, the legislative changes they expanded the definition of harm in order to qualify for a temporary guardian from just physical health harm to include harm to the person's health, safety, and welfare. So that is actually an expanded definition of when a person can qualify for a temporary guardian. So guardian responsibilities: review educational materials, including videos and handbooks. I provided the link to where you can look at those videos and the handbook. If you are appointed guardian, you will need to fill out a form certifying that you have watched these videos. The guardian is obligated to consult with the protected person when making decisions whenever possible. They are obligated to try to make decisions consistent with the protected person's desires, as long as those desires are consistent with the person's well-being. They are responsible for managing the financial means of the protected person, as well as providing the maximum benefit for the protected person, which means they will have to seek public benefits for which the person may be qualified. And then the filing of guardian reports. So there is a form available that must be used. I provided a link to that form as well. In the form, they're going to provide specific information about the protected person's health, living arrangements, and finances. So giving a summary of what they've been doing for the protected person. The first report is going to be due 90 days after the initial appointment. And then there is an annual report due within 30 days of the anniversary of the appointment each year. If you do miss that deadline, they can apply fees of $25 per day. And finally, the guardianship does have the obligation to request that a guardianship be terminated if a less restrictive alternative to guardianship becomes appropriate. So if the person regains capacity, or if they improve to a point where they could execute a financial or healthcare power of attorney, the guardian is responsible for informing the court that the guardianship should be terminated. And then finally, just as a last note here, a guardian is not required to use their own personal funds to provide for the protected persons. And guardians are not personally liable for actions of the protected person. However, there are exceptions to that rule for situations of negligence. So if the person is able to prove that the guardian was acting negligently and they should be liable for the action of the protected person, that's the only way they would be liable for the action of the protected person. So I just wanted to provide finally some resources to look at if you want more information. The New Mexico court website has great information about the adult guardianship process and legislative changes. The Office of Guardianship website is a great resource for educational material if you think you might need a guardianship or want more information about alternatives. They also have an application for services, and they provide guardianship services based on income eligibility. And they additionally handle complaints about guardians. And then the State Bar Directory is the last resource I have here for if you decide to seek guardianship and you want to hire a private attorney, you can look up the attorneys practicing in New Mexico in the area of adult guardianship. All right, and that's all I have, so we can transition to questions.
Well, Ashley, thank you very, very much. And we're getting some questions rolling in. Could you go ahead and unshare your screen? For everybody on the Zoom meeting, Ashley's charts will be posted with the YouTube video. So all that information will be available if you weren't able to write it down really quickly, which I wasn't, but it will be there. So please look at it there. Our first question comes from Jim, and Jim's question is, a person with mental illness may recover to various degrees. What is the process for going from an adult guardianship to a limited guardianship?
Yes, so the process for changing a guardianship is not very formal. It can be done just through a letter to the judge or reaching out to the attorney who represented you and taking a formal motion to modify the guardianship. Since the statute very specifically says it should only be used as is necessary to protect this person, the court's going to be very open to change it to a limited guardianship. So I think just taking action as the guardian to bring that to the court's attention is going to get you to where you need to be.
Thank you very much. As I listened to all the different guardianship options, it was a little overwhelming. And my question is, if I were faced with that situation, I don't know that I could do it by myself. Do most people need to get the support of an attorney to do the things you described?
I would say, unfortunately, yes. Typically, an attorney is going to be involved for the petitioner. There are just very specific requirements for the petition. For finding the guardian ad litem can be difficult. So I would say, if you can afford it, hiring an attorney is going to be the right call in this case. Also, I didn't mention, but the cost of this action can come out of the estate of the protected person after the guardianship is granted. So you won't necessarily have to take on the burden of the financial cost of it. And then if you can't afford it, the Office of Guardianship is a good resource for doing it based on income eligibility, because they will provide the guardian ad litem, the court visitor, the petitioning attorney cost, because you qualify by their income eligibility. It is possible to do this pro se, but there really aren't very many forms available, so it would be very hard.
Would it be possible, even afterward, for you to send us the link to the Office of Guardianship? Because that sounds like a resource that our members who may not be able to afford this would need help with, and that would be a useful thing to know. Now, one of my questions is, if someone were a patient at Christus and they needed this kind of support, would that be something you could support them with? And if so, how would they get in contact with you?
Yes. So typically the cases out of Christus St. Vincent Hospital, when they need a guardianship, it's going to be a case where, possibly they aren't even communicative. So it will be obvious that a guardianship is needed. It just depends case by case whether I can be the petitioning attorney or not. But even if I agree to be the petitioning attorney, I still need to find that entire legal team, the guardian ad litem, the court visitor. So it just, to get connected to me, typically the extreme cases will be referred to me through the staff there because they are familiar with my services. And then I either refer them to the Office of Guardianship or suggest hiring a private attorney if they have the funds, or consider taking the case myself. And then if you feel like you want to consider guardianship and the doctor or the case manager isn't recommending it, I would just ask for the New Mexico legal aid attorney, and they should be able to connect you with me.
Okay, so what you said is, what I hear you saying in some sense is you're sort of there to be able to advise people who might need this, and you may or may not end up being the attorney depending on the case, etc. But you are there, and people can reach you just by simply talking to the staff and saying, I think we need some legal help, and could you help me get to the New Mexico legal aid attorney here at the hospital? And they should be able to get people to you one way or the other.
Yes, exactly. And providing resources to family members is a big part of my job at Christus St. Vincent. So talking to family members who are considering whether guardianship is necessary, whether it's the right choice, just advising them is a big part of my job.
Thank you. Do you see a lot? I mean, in a typical week, do you see one of these cases, 10 of these cases? You know, what's the flow?
Yeah, I think it is surprising how many people are impacted by this issue. I don't have an exact number, but I would say, you know, since January 1, I've probably talked to, 3 or 4 family members considering this. I've consulted on 2 or 3 cases where they definitely need guardians. So it's happening more than you would think is my impression.
Okay, thank you very much.
There's a question.
Oh, yes, go ahead, please ask your question. You're muted, Miss Tong. You need to unmute, please. Thank you.
I have 2 questions. Number 1, when the representative payee becomes unable to serve, what happens?
So the representative payee appointed through Social Security Administration?
What if the person becomes, not able to serve?
Yes.
Who's going to take over? How to somebody else take over? What is the procedure?
Right. So the Social Security Administration will need to be notified. So, for example, there's a notification of death of representative payee. There is also a way to report just mismanagement of funds. I think those 2 options are going to be for those specific situations. And then if they just don't want to serve or they're unable to serve, they can withdraw as representative payee as well. And then the person can either take over their own management of their benefits, or they can seek either a professional representative payee or someone else who can serve as the representative payee to replace that person.
Yeah, what if this person is not able to appoint another payee? Is not willing to?
Yes, so the options in that case are to take back over the management of their benefits, or to seek a professional who can serve as representative payee. The ARC of New Mexico, I believe, provides representative payees.
What if another family member continue to apply to take over?
Yes, definitely. Yeah, if there's another person who's willing to do it and step up, they can just be substituted in.
Okay, so you go to Social Security to do the paperwork of substitution, and that's possible.
Exactly. Yep.
Okay, all right. Second question is, the treatment guardian, does treatment guardian has the power for forced treatment?
So yes, I believe so. If the court is presented with a treatment plan by the physician and it calls for forced treatment, and the court agrees that that's in the person's best interest, they will grant that specific authority to the treatment guardian to be able to authorize that. But it will depend on the physician actually presenting that method of treatment and the court agreeing that it's in their best interest before the person would be able to do that.
Okay, thank you.
Can I ask about that? I thought New Mexico did not have a forced treatment statute. They have assisted outpatient treatment, but that's really still a voluntary program.
Oh, okay. Maybe I can follow up on that question then.
Yeah, my understanding was, as a treatment or medication guardian, that you really didn't have much power as the guardian to do much except consult with doctors about change in medication, or you could advise the doctor if somebody stopped taking their medication, but that was about it.
And to consultant.
Yeah. I'll look into that because I know that it's meant to cover all of the mental health treatment in the definition. But maybe there is a secondary statute that does not allow that. So I will look into that, and we can send a follow-up out.
That would be great. Could you also, you mentioned ARC of New Mexico as a place that provided payees.
Mhm.
Could you send us a link for that so we can add that in the information we distribute because people might want to actually use that?
Yeah, definitely.
Thank you. Are there other questions? Because I certainly want to make sure everybody's listening has a chance to ask their questions. I guess since I had a few others, and one of them was, we're talking about guardianships, but you mentioned 4 ranges of service you provide as going off of your initial wonderful cartoon. Can you give us just a real quick thumbnail of, as you look at how you spend your time there supporting people, how much of it is like landlord-tenant relations, how much of it is some of the other things that you mentioned, just so we can get some feel about what the legal needs are that the people that come into Christus and secure your assistance.
Yes. So it really varies based on the healthcare facility that the medical legal partnership is embedded within. So the hospital provides acute care, which means it's going to be more emergency settings. So I do see a lot of decision-making cases out of the hospital. I get requests to come in and help people with power of attorney and other planning documents. Quite often, I see domestic violence and the need for order of protection out of the hospital quite often. And then the high utilizer group at the hospital, that can be the homeless population, people struggling with drug abuse. So if I get connected with those people, I can sometimes find a legal issue because typically if you're homeless, there's an underlying legal issue that maybe could help. You may be entitled to benefits. You may have been wrongly evicted. So the high utilizer group often leads to civil legal issues I can address.
Thank you. Now, the other thing you mentioned civil legal issues. My understanding is you support people with civil legal issues, but if they have criminal legal issues, that goes to a different set of attorneys.
Yes, that's exactly right. So I am only allowed to practice in the civil areas of law. I cannot practice in criminal law. So if you have a criminal case pending, you'll want to call a public defender or a defense attorney to address that issue.
Wonderful. Okay, I got one last question, and this is kind of a broad one, and that is, as you do what you do and you look at the people coming in and their needs, where do you see that our state statutes could be much better in supporting people in their needs for just the civil legal support in times of crisis?
Yeah, well, I think where all legal aid attorneys probably would say right now is housing protections. With the COVID-19 pandemic and the eviction moratorium, I think it really highlighted issues in New Mexico, but also nationally with housing availability, housing cost, access to housing, fairness in eviction proceedings. So that's the area I think that we probably need to pay a lot of attention to in New Mexico going forward.
Thank you very much. And seeing no additional questions, I'm going to close out our presentation for tonight. And I want to thank our speaker enormously. Fantastic presentation. Thank you very much.